following provision has been made. In the matter of appointment, priority shall be given to those eligible candidates who possess the minimum qualification as specified by the National Council of Teachers Education and MHRD, and thereafter the eligible candidates with the relaxed qualifications specified by MHRD may be considered, and if candidates with relaxed qualifications are considered as teachers, such teachers under the relaxed qualification norms shall be appointed with an undertaking to acquire the minimum qualification specified in the NCTE within a period of 2 years from the date of appointment. Under the said rule, sub-rule 3, 8 notes are there which would be taken into consideration if required. When the petitioners filed the petition, they wanted the authorities to file a report disclosing name, numbers, rank, category, etc. of the non-trained candidates who have been recruited by the board from 2014, including the date of recruitment, and to treat the petitioners equally with the non-trained candidates, etc. During the course of hearing, the petitioners disclose various particulars collected from the publication made by the board in its website, showing that there were serious illegalities in preparation of the panel of 2016 recruitment process when viewed in respect of untrained candidates at the time of recruitment, and while disclosing such particulars, they made it clear that all their allegations of illegalities in recruitment were in respect of untrained candidates at the time of recruitment who were given appointment against 2016 recruitment process. And at the same time, it was made clear that they do not have any grievance with respect to the trained candidates who were trained at the time of recruitment and were given appointment in the 2016 recruitment process. Therefore, the candidates who were trained at the time of recruitment are outside the scope of this matter. The petitioner prayed for filing supplementary affidavit which was granted, and from the supplementary affidavit to the writ application, it became evident that all the petitioners had qualified TET 14 and participated in the 2016 recruitment process, and they were called for interview, but they did not get the job. They were called for interview, but they did not get the job. They were called for interview, but 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 they were called for interview, but
আদা ঠিক চলে যাও আদি একটা চ্যানেল চাই এই দেখাই তো এটা দিয়ে দাও এই না
14.191, whereas all West Bengal 824 candidates who scored below 13 were appointed, and the petitioners prepared a tabular sheet to that effect and enclosed it as Annexure B to their exception to the report filed by the board dated 11/1/23. Such exception was filed in the form of an affidavit affirmed on 24 January 23. It was also stated in the exception that list of the last impaneled candidate of different categories, namely General SC, ST, OBC A, OBC B, was not given. I have found that there was no reply of the board in respect of the allegations, and is aforesaid in the affidavit in opposition filed dealing all the pleadings of the petitioners. From the pleadings of the petitioners, it is
বেকার ডবল নেটে ক্লিয়ার লাগছে
ডবল খাবি ওটা বন্ধ করলে এটা বন্ধ হয়ে যাবে মনে হচ্ছে কি
না আর কি এইটা তুই চালাই ওটাতেও চালাই নেটটা ডবল হবে না যদি বন্ধ রেখে দাও নেটটা কাছে
বন্ধ হয়ে গেল
চলবে দাঁড়াই এটি কেন আর কোন কিছু করে কাটি গরম কাট পানি হবে না লোক দেখবে না নাহলে
কাকা
ঠিক আছে কাটে
না কাটু
এটি কেন আর কোন আসি
আদি দেখো যাও
কি দেখা যাচ্ছে তো
সাই ভিউজ করলো
তো ভিজিটি টিপা
ও কষ্ট
পাঁচজন দেখে আলা একা আর কাটলো
তো বন্ধ হয়ে গেল না ঘুরেই তো নি দেখা যাগা চলে যাগা
দেখো তুই তো রিচার্জ জানি তুই তো 1.5 MB করে পাবি
তুই দেখা হাটা নেই
in respect of in holding of aptitude test, the chairman of the board in his report said that the aptitude
আছে কি নামটা চ্যানেলটা কোটের সরকারি চ্যানেলটা দিলে কি হবে
এবিপি ছাড়া নি
না এগুলো ছবি নেই
এই তো এটা দে
দে হ্যাঁ এটা দে
এটা
which is part of the paper book to show that in every district, my lord, aptitude test was taken. But with respect, the honorable judge do not refer to any of them.
বেশি টিপাটিপি করি
The honorable judge confines this adjudication to whatever was elicited under section 165. Readings and evidence on record, my lord, in my very respect. The order passed by this court in this matter on 6/2/2023, not challenged till now, is required to be quoted. My lord, that order is quoted, but I placed that order, my lord, with the
So, Mr. Dotto, where they called for the aptitude test.
yes, yes.
দেখতে পাচ্ছেন
We have all records, NS. I'll not go elsewhere.
So,
With this paper book
But
itself.
the evidence which was extracted as you were submitting, that is relating to the issue whether aptitude test was held or not.
The issue which the honorable judge considers at the time of final adjudication is only confined to whether or not aptitude test was taken.
চাকরি
Yes.
মামলা
Although, my lord, no pleading was there.
শুনানি চলছে লাইভ শুনানি
That's why, my lord, I've taken a lordship through the writ petition. Then, my lord, if your lordships may kindly skip over the table
হ্যাঁ
Excellent.
at page 617 after the table. No question were asked by the appealing parties to the above interviews. The evidence kept on record. It is to be remembered. This is the quotation of that order. I skip over those. Now, please take paragraph 10.
করে দিই
হ্যালো চলে চলে
Then page 618, para 10.
হ্যালো বন্ধুরা আপনারা
Therefore, the marks given to the candidates against aptitude test is wholly illegal and false
কলকাতা
exercise
হাইকোর্টে
to hoodwink all concerned, including the
মামলা শুনানি চলছে লাইভ দেখছেন এই মোফা চ্যানেল পর্দায় দেখতে থাকুন
paragraph 10.
Yes.
But so long, my lord, the finding was that no aptitude test was taken. The interviewers have made contradictory statements in course of their deposition. Now, kindly see paragraph 10. Therefore, the mere marks given to the candidates against aptitude test is wholly illegal.
Maybe the judge thought that the aptitude test which has been held is not in terms and in consonance with the
Well, let us see, my lord, whether my lord, that has been held or not.
this issue as whether aptitude held or not. This I think will go because subject to what you said. Because maybe Lordship was proceeding on the basis that test which was held was a sham test.
কমেন্ট বক্স
নাইস লিখে নাইস সুন্দর
Was a sham test.
Right. My lord, there cannot be, my lord,
Two versions.
two versions. Either the aptitude test was taken. If taken, it is faulty or correct. That can be one situation. The other situation was no aptitude test taken.
Okay.
So long, my lord, we had a understanding from the judgment that
There was no
no aptitude test.
Hmm.
Therefore, the marks given to the candidates against the aptitude test is wholly illegal and false exercise to hoodwink all concerned, including the court. The board has not given any reply in respect of awarding 9.5 out of 10 marks to a large number of candidates, which is absurd and an impossibility, especially to those whose academic score and test score were very low. The table given below substantiate the allegation apart from 121 pages booklet, spiral binding, which is on record. The spiral binding, Lord, cannot be a pleading or an evidence.
So who made the spiral binding?
We are the petitioners. Read petition.
Record with us.
Yes, yes. That will we have put in the paper book. It's in the paper book.
Yes.
In support of their allegations as to corruption in awarding marks in the interview, the petitioners have filed a booklet of 121 pages on the basis of which it has been alleged that the candidate whose marks were very poor in secondary, in higher secondary and in TET has been given 9.5 out and 10 marks, that is full marks out of full marks 10, that is the perfect 10 in the interview and aptitude test. No aptitude test was taken at all. and the allegation that there was no aptitude test which has been proved before me. Who has proved this? The proof has to be preceded by an allegation,
লোগোটা
an assertion, a pleading.
মিথ্যা লোগোটা রাস্তা মিলতেছে বেটারছে
Noted by me that in the academic assessment and TET, one, the maximum marks that could be given against secondary examination score of a candidate was 5. The maximum marks that could be given to a candidate against higher secondary examination score of a candidate was 10. The maximum marks that could be given to a candidate against TET was 5. Therefore, the maximum marks that a candidate can get against the above three heads is 5 plus 10 plus 5 is equal to 20. Now I give example of a candidate before giving a table prepared from the document or record, that is the 121 page booklet. This candidate has got 2.866 in TET out of 5, 1.462 in secondary out of 5, and 3.050 in higher secondary out of 10, totaling to 7.378. But was awarded 9.5 marks in interview and aptitude test. Aptitude test was not taken out of 10, whose total score came to 16 point so and so, and thus he became eligible for appointment as a primary school teacher. Huge number of such absurd awarding of marks has come to light through the said booklet prepared from the particulars published by the board. Miller examples given. For example, Putul Bormon Singh, total marks in the academic qualification is 7 point something, and interview marks is 5.0. Similarly, Munimala, etc., etc. This is the honorable judge records. Then kindly, after the table, para 15. The board has not given any reply in respect of the allegations of the petitioners in the pleadings as to non-empanelment of the reserved category in the panel for general category candidates of those reserved categories who got better marks than the general category candidates in open competition. Thus, the board has violated the law declared by the Supreme Court and has committed extreme illegality. Though the relevant Rule 7 of the recruitment rules of 2016 mandates constitution of the selection committee, no selection committee was constituted for the purpose of selection of eligible candidates and preparation of panel of such candidates for appointment of teachers. It was done by one outside agency, a third party, which was not at all a part of the board, and this third party was named as confidential section of the board.
আর কি করবো রে উঠাই নিবা
This is clear violation of the recruitment rules. The board has maintained complete silence. From the gross illegality in the selection procedure in recruitment exercise of 2016 conducted by the board, it is clear that the board and its officials, including the former president who is now in custody so and so, conducted the whole affair like affair of a local club, and now it is gradually coming to light by investigation of Enforcement Directorate, that jobs of primary school teachers were actually sold to some candidates who made money,
একসঙ্গে কেন বিকাশ
but who had the money to purchase the employment. A corruption of this magnitude was never known in the state of West Bengal. A former education minister, the former president of the board, and a number of middlemen through whom the jobs were sold like a commodity are now behind the bars, and the CBI-ED investigation is being continued now in full swing. With respect, paragraph 17 has got nothing to do with the merits of the matter.
It's a scam, Mr. Dotto.
That scam, what they say, scam, please see whether at all there was anything in the petition.
Right. You have told us
Yes,
that there was
nothing was there. Simply, Millard, using this catch expression, scam, corruption, doesn't mean that a case is proved. A case has to be proved even if it is scam.
So there will be no perception of the judge.
Millard, in that case, Millard, the judge should first release the matter.
First,
Release the matter with respect.
perception in the sense from the record.
Millard, no, these are not on record. These are the personal views of the judge. But how could the Honorable Court get the name of that third agency?
If it is ultimately shown by them that they are,
Whether it is shown by them, right?
these are all factors inextricably bound. You cannot segregate it without.
No, these were not placed before the court. I'll come to all the pleadings one by one. It has to be there in the pleadings.
The pleadings you have shown.
Nothing is in the pleading. I'll come to the other pleadings. I've just taken your lordship through the writ petition. Other things where and the sequence of pleading is also very important. When did the court invite which pleading? That is also very important. We'll have a short list of dates for that also.
So that we will hear. We are just interacting with you.
Right.
We are asking you.
Yes, yes.
When there is such a heart-throbbing issue of scam, which you say that it has to be different definitions can be given, but it is a fact that there had been a scam in respect of several education.
That will not vitiate the other selection process. Paragraph 17 has got nothing to do with the merits of the matter. One selection process said to be bad doesn't mean the other.
Can be argued against you that in order to divert from that issue, you are taking up the very basics as to whether there were any issues. Maybe this may be an argument on their side.
Yes, definitely. Yes, but I will deal with those also.
Yes.
But otherwise, we are the whole the writ jurisprudence, has to be rewritten.
Yes.
Where your lordships have in a number of judgments held that whatever is there in the pleading as well as in the evidence, the court will only look into that.
Even except in extraordinary cases.
Yes. That extraordinary case has to be made out by the parties, not by the court. Court is not going to make out a case for one of the parties.
Yes. Yes, page.
Yes, ma'am. But I was placing paragraph 17.
Yes, 17. You have finished 17.
Yes. Now kindly take paragraph 18.
Yes.
Now kindly see but how we are being dealt. Acha, 17 when I have not started. From the gross illegality in the selection procedure in the recruitment exercise of 2016 conducted by the board, it is clear that the board and its official now please take paragraph 18. This is very important for me. Kindly see not how my arguments have been dealt with. It is a matter to be noted that the board in its affidavit in opposition while dealing with the pleadings of the petitioners, instead of addressing the allegation of corruption and illegalities in the recruitment process, raised some niceties of law and some principles of law, but however nice or however laudable, those principles may be, this court as a court of justice will fail to deliver justice, knowing fully well that sense of justice is much above the sense of law. If the writ application is thrown out on such niceties of law, as this will mean that in the name of preserving the law, the corruption would be protected, which a constitutional court can never do, keeping in mind the soul of our constitution and the constitutional conscience. I say that in this recruitment scam, stinking rats are being spread. So whatever rubbish I have said, that has to be dealt with by the court. Kindly see the next sentence. Even more alarming, the board placed some judgment before me in support of the niceties of the legal principles, which I do not find have any applicability in the face of the magnitude of the stinking corruption in the recruitment exercise of 2016 conducted by the board. These judgments are not required to be mentioned at all. This is how, my lord, the advocate is being dealt.
ঠিক আছে
Say that these judgments are not applicable because of so and so reason.
At all in the facts of this.
No, he has not. I have referred to at least 20 judgments, not even recorded. That is why, my lord, with respect, my lord, the honorable court, my lord, bypasses the application of the principles by saying that these are niceties of law. As if, in writ court, niceties of law is not to be argued. It is a Bhakcha's court. Kindly see. Now, kindly see the expressions thereafter. Those judgments are not required to be mentioned at all in the factual situation of the case, as those are bright stars of the space, much above the ground realities, in which the unemployed youths live with tears in their eyes, because this recruitment scam is a crime against the society and also a fraud, where the board and its former chairman was well aware of the rules of the recruitment but cared a fig and started a play to hoodwink all concerned. I will only say that fraud unravels everything. Who has unraveled the fraud? Kindly, my lord, recollect.
Application at this. Yes. Yes, Mr. So there are total 44 appeals in this. We were told. Now those are arising out of the same judgment. Now how many petitioners were there in all these matters? Total number of petitioners, how many?
May I say this?
How many challenged the selection process?
140.
Only 140.
Only 140.
More than 140? No. 140 retreats. Now, any other person came into the zone?
No, not in the appeal, before the writ court.
No. Before the writ court, we are asking. 140. All the 44 appeals, let us clear out the facts. All the 44 appeals are arising out of the same judgment. And all the appeals are dealing with the case of 140 writ petitioners. There were no other persons. Whatever application for addition has been filed is by the teachers who are already in service. Right?
Not only that, my lord, who are in the same footing of the petitioner, that application is also filed because their petition is also pending, and the board submission is that, my lord, due to this pendency of this matter, they are unable to address the court. So that's why the additional party and one of the additional party.
লাইভ দেখাই তোমাক লাইভ হাইকোর্ট থেকে আমার ইউটিউব চ্যানেলের মাধ্যমে
My lord, can do already.
দেখো ঘাটে আমার ছবিটা সব
কিন্তু কি করছে কথা?
In the first order, it is mentioned, my lord, can do is already allowed.
দেখো ভালো বুঝা পাবেন সব চারটা অবধি চলবে চারটা অবধি
Who are the unsuccessful persons? So do you have that chart? How many persons in total are there? Anyway, please ascertain that. Yes. Yes, Mr. Doctor. No breather. Continue.
And there are 7 petition pending.
Yes. We are on paragraph 20.
Yes. But I'll just finish this judgment, Miller.
Yes.
Para 20.
Yes.
Then in paragraph 20, the affidavit in opposition of the board was filed when all pleadings of the petitioners, including the particulars placed in the court, were served and kept on record, and the board did not deal with those allegations and those material facts and necessary particulars. In such circumstances, I allow the writ petition. The appointment of all 36,000 who were untrained at the time of recruitment in 2016 recruitment process conducted by the board in the post of recruitment primary teachers were cancelled for various reasons as elaborated above. The board shall immediately arrange for a recruitment exercise. Rest is Miller how to implement the order.
কি করে যাবে পদে 3:30 বাজে গেল একটু রোদ লাগুক কে ও
So this fresh recruitment exercise which the single judge directed would be restricted to the self-same persons.
এলা এই চাকরি বাতিল আছে প্রাইমারির
Yes.
ওটা কেস চলে কেস কোর্টত
So, my first is Millard.
Then
But the other is Millard how Millard
Look,
the
the political
judgment is
order,
worked out. Yes.
such they will be acting as
Yes,
paralegals.
that may not be Millard
Okay, yeah.
essential for the present.
3:30 বাজে গেল
Therefore, Millard,
হাই
this is how Millard the litigation proceeded. Millard, one facet I have demonstrated before the court. The other is Millard as to
তোরা আগে উঠাই
when Millard the pleadings were called and what had happened in between.
3:30
I'll place those also. Then Millard,
কে দিল কি কে দিল এ আফরেদ
but maybe come back after
Think
the
about that,
petition.
Why vacation, sir?
হাই
We
বাচ্চা একদম
you can finish
Relax,
your
relax,
argument
relax.
at least because
হাই হাই
your argument, your judgments we will take into account.
হাই ওটা একটা ফোন করবো হয়তো মোবাইল
Wait, wait,
থেকে করে হবে পরে যাবে ওইটা মতো রাখা হবে নাকি নাম্বার নিন
How long will you take, Mr. Dotto?
নাম্বার
Millard, Anna,